My witnesses are going to take the 8 minutes. Thank you.
And you're going to start and then we'll swear you in, Mr. Lyman.
My name is Natalie Clausen. This is a case today of dishonesty, deception, and delay in the highest levels of our government. We are here to request access to Governor Cox's signatures that we had a right to view prior to the primary election in 2024, but which unlawfully were denied to us. This has been a long journey, but we are persistent and we believe in the rule of law and we believe in justice for all. We request that the hearing officer take the steps today to right this wrong. On June 19th, 2024, before the primary election, I received an email from Ryan Cowley, the state elections director, informing us that Governor Cox had submitted 592 unviewed signatures above this required threshold. This was a really big deal. Most candidates submitted thousands of extra signatures. This gave him a very narrow margin. So we wanted to see these signatures, given that there was a criminal investigation regarding forgeries was underway in Washington County regarding that same signature company that Governor Cox had employed. We didn't expect any pushback. Several people had requested access to view these nominating petitions for other candidates, and they were granted access by both the Lieutenant Governor's office and by the county clerks. However, when we went in there to ask them to view these packets, our requests were denied. We filed grammar requests, we appealed the denial, we took our case to the 3rd District Court, and we've never seen these documents. And starting in July of 2024, the Attorney General would maintain in all of our 3rd District Court hearings that there were almost 600 unreviewed signatures. But were there 600 signatures? We don't know, and we still don't know. In September and October of 2024, the state auditor and the Office of the Legislative Auditor General issued audit conclusions, each citing a different amount for these unviewed signatures, not nearly the 600. So these conflicting numbers caught the attention of Michael Clara, and his quest to reconcile these numbers is what brings us here today. So additionally, we have received other conflicting information regarding a criminal investigation into Governor Cox's nominating petitions, and we're here to resolve those issues as well. In response to our grammar request, the Lieutenant Governor and the AG maintained that there was no criminal investigation and into these signatures, so we were never able to introduce that evidence into court. Both of these things affected our court cases, the number of signatures and this lack of investigation. However, in response to Michael Clara's grammar request, both the Lieutenant Governor and the Attorney General are now admitting that Governor Cox's nominating petitions are in fact part of a criminal investigation. So the information is changing. They are saying this despite previously denying that this investigation existed. The petitions that Mr. Cheney is now referencing that are under investigation from Benson and Angela that we're requesting today, through the charging document state that between January and March 10th, the defendant turned in 48 packets with over 2,000 signatures, and 84 of these signatures were deemed valid. The problem that this presents to the Lieutenant Governor and Attorney General is that the election code states that once they receive these packets, they have 14 days to enter them into the system, into the VISTA system. And so once, to verify them. So in other words, these signatures that were submitted by Benson Angular could not have been in this unviewed and unverified category because they were turned in well before this threshold date. So they had 14 days to review them. They should have been entered into the system. So in fact, we know that the last signature packets that were counted by the Davis clerk were turned in on March 15th, and he turned his in well before that. So according to the explanation proffered by Mr. Cheney, these were entered into the VISTA program, and there should be a record. But the problem is that Angular is not listed as a signature gatherer on Cox's nomination petition. So there, for some reason, he's not included in that list. GRAMA 63G2-305.5, the code states that the records custodian shall, upon request, provide this list of the names of the individuals who signed the petition. We should be able to have access to this. If the Davis County clerk did not follow the procedure described by Mr. Cheney in his documents correctly, then the list is the nominating packet itself, and the nominating packet should be released to us as the list.
Where are you in, Mr. Lamb? Do you swear that the evidence you will give in this hearing shall be the truth, the whole truth, and nothing but the truth, under the pains and penalties of perjury?
Yes.
Turn the time.
Thank you. So on July 3rd, 2024, we filed a grama notice of appeal, 3rd District Court, to view all Spencer Cox signature packets. On July 17th, 2024, Mr. Cheney, on behalf of the Lieutenant Governor, filed a motion in opposition to our TRO, informing the court that Spencer Cox signatures were verified, quote, through a rigorous and statutory process, end quote. And he goes on to outline the process in much the same manner that Natalie just quoted in his statement of facts to the records director. At one point in his statement to the court opposing our motion for a TRO, Mr. Cheney referenced, quote, petitioner's misunderstanding of the process, end quote, then said, election officials tasked with verifying hundreds of thousands of signatures stop verifying signature packets once that candidate's verified signatures meet and slightly crosses the statutory threshold. Here, election officials had in their possession almost 600 additional signatures from Governor Cox that they did not check because they had already verified enough petition signatures to qualify Governor Cox for the ballot. As Natalie just outlined, it appears that these almost 600 signatures were not really additional signatures, rather they were signatures that should have been processed and entered into the system in accordance with this, quote, vigorous statutory process that Mr. Cheney cited to the court. Moreover, in violation of this vigorous statutory process, Mr. Cheney pointed out in his statement of facts to the records director, quote, the clerk sent those packets unreviewed and unverified to the office of the Lieutenant Governor. After receipt of the flagged packets, the Lieutenant Governor's office transferred the packets to the office of the Attorney General for further review. So the election workers did have these in their possession, as Mr. Cheney stated in the account. Moreover, it begs the question, who verified these unviewed signatures? According to Mr. Cheney, it was not the Davis County Clerk. Yet last year, Mr. Cheney represented to the court, quote, for candidates seeking statewide office, the Lieutenant Governor's office contracts with the Davis County Clerk to verify signatures in order to avoid conflicts of interest, end quote. So if the clerk did not verify the signatures and the Lieutenant Governor did not, who did? That is the list of names that are a matter of public interest and should be released. We know the list exists because the Lieutenant Governor and the Attorney General can quote the number. And the list should be released to the public regardless of the format. Utah Codes 63G 2201, paragraph 12 states, a governmental entity may not use the physical form, electronic or otherwise, in which a record is stored to delay or unreasonably hinder the rights of a person to inspect and receive a copy of the records under this chapter. Now, I want to add, running a campaign is one of the most difficult, complex, expensive things a person can do, especially for a statewide race like the governor's race. Ours involved hundreds of volunteers, hundreds of thousands of engaged voters, millions of dollars, and truly the heart and soul of so many people. I expected a certain amount of official mischief, but the level of actual collusion in this case is staggering, and it continues to astonish those who take the time to understand what took place leading up to the 2024 Utah GOP gubernatorial primary. Thank you.
Just one question, if I may. Was it your stance, Mr. Clara, that all packets need to be entered into Vista, even if they do not, even if the threshold number has been reached?
That's a preliminary. Sorry, excuse me.
I mean,
Say it again.
it was mentioned that there is 14 days to review and enter into Vista. So is that all packets, or does it matter that they have reached a threshold?
So my understanding of the process, and it's been confirmed in the documents that Mr. Cheney provided, is that, and it happened, he explained it last year too in the court, is that as they're receiving those packets, the clerks they're entering them into Vista. And then like what Natalie was quoting was in the election law, it says that the clerk has 14 days to enter those into the, I don't know if it says 14, it says 14 days to process them. And the process would be entering them into Vista. And so I think the argument is that when Mr. Cheney says that, or the concern is that when he says that these are additional packets, that once the threshold is met, then they stop the process of entering things into Vista, that these are additional signatures, and we're arguing that that can't be if they were received prior to the, I think it was March 15th when they declared the governor had met the threshold.
Thank you. Mr. Chief?
Thank you. I get that there's a lot here, and we're talking about, as I understand, two separate sets of packets, signature packets, each set of which was not reviewed or verified by the Davis County Clerk's Office. And while I think the petitioners have generally stated the process for verifying signatures in a nomination packet, the conclusion that just because a clerk received the packets, that those packets were either entered into Vista or should have been entered into Vista is not correct. And just as if we were going to a buffet to eat, for example, I fill up my plate, take it back to the table, eat until I'm stuffed, and then I still have food on my plate. And that extra food there doesn't get eaten, doesn't get used, doesn't get, and these unreviewed, unvalidated signatures in a campaign nomination context are what's left over. That is, the clerk staffs the office. They receive not only the governor's signature packets, but from many, many candidates. And so they may have referenda, they may have initiative petitions as well. All of those signatures have to be validated and verified up to the threshold, the statutory threshold number. And that's what's happened here. And so directly to these requests and appeal 002 and 194, well, the other kind of process is that as signatures are being validated, they're entered into the Vista system. And it's from that system and that data entry that a list of the names of signers of a petition is created. And so when petitioners asking for a list of the names of people who signed these unverified packets, the list doesn't exist because their names weren't entered into Vista, and therefore there's not a list that's generated or kept within the daily practice or what's the phrase, the everyday business of the office, right? So the Lieutenant Governor's office cited this provision of GRAMA 63G2201, which states that in response to a request, a governmental entity is not required to create a record, compile, format, manipulate, package, summarize, or tailor information, or provide a record in a particular format, medium, or program not currently maintained by the government entity.
I may, so the information was not entered into Vista. The packets are still in the custody at this point of Lieutenant Governor's office. So the information that would be necessary to have to make a list is still available. It's just,
Yes.
you're not required to
Right.
make a list.
Right. And that list wasn't generated in the ordinary course of business of counting and validating these signatures, because that process necessarily involves the clerks and the Vista system.
And so how do you respond to the 305.5 where it says shall? Does that not mean that they have to make a list?
Well, there's the conflict, right? And our interpretation, or the Lieutenant Governor's office interpretation, is that we don't have the list, and we don't generally make a list relating to any packets that were surplus or that weren't validated, and therefore 201 kicks in, and perhaps we don't have to do that, and that's the basis of it. Now, they've said today that the packets are the list, and I get that that's a different kind of format or whatever. The packets, and we've spoken about these two sets. One is the set that was eventually included in the Office of Legislative Auditors audit, and the others were handed over to the Attorney General's office in furtherance of whatever the investigation they might take, and that's where those still are.
So there's one packet is with the Attorney General's office and one packet is with the state auditor, or
no, the state auditor, we handed everything back to the Lieutenant Governor's office, and then we packed them up, and they're currently, I mean, the Lieutenant Governor is the custodian, but the actual records are in the state records archive.
So that's what the storage is.
Yes, yes. So
It's one packet, right?
yes,
Like,
that's the one that I think applies to Appeal 194. And then the other one, 002, are the packets that have been handed over to Lieutenant Governor. So
I apologize for blending those together.
no, I think it's convenient and actually helpful. So thank you for doing that. One issue that hasn't been kind of fully fleshed out here as to, providing access to these records, to these signature packets, is that the Lieutenant Governor's office has, in the various grandma requests and correspondence between us, or the Lieutenant Governor's office, and Mr. Clara and Ms. Clausen, they understand that the opportunity to view these packets as outlined in 305.51B, which says permit an individual to view but not take a copy or image of the signatures on a political petition. The qualifying issue there is that in section 1, it makes clear, except for a name or signature classified as private under Title 20A, Chapter 2, the records custodian shall provide a list of names and permit an individual to view. And so while we've proffered the opportunity to come in and view any of the signature packets, that's subject to the obligation to redact and not hand over names and signatures that are treated as private or withheld under the statute. But
yeah, I'm sorry. I've been taking up a lot of time, so I'll give you additional time as well. But just want to make sure you're offered the opportunity to come view the names. Was that of the 2 unreviewed packets or all of the signatures that were counted?
all of them. In the early response, and I think Mr. Clara mentions this in one of his, the actual requests, 002, the Lieutenant Governor's office did give him a list of 32,000 names or something like that. And of course, the threshold for the governor's race for signatures is 28,000. And so it's not like they haven't had information to work with. It's just that we couldn't or don't create a list from the excess or superfluous signature packets. And so that's, but the offer's out there. I mean, they exist. But in this instance, in these particular grandma requests, the point is the Lieutenant Governor's office did not violate the law. They did not delay or be dishonest or deceive or collude. Instead, they followed the statute as it's written.
I can give you a little bit of time to finish, or are you with it?
Sure, I'll take it. Thank you. I want to read from the order of the court in the third district court case that Ms. Clausen referenced. The Lieutenant Governor's office did appear in that case and filed a motion to dismiss both their TRO motion and then later motion the case after the TRO was denied. And this goes to the weighing of public interests in as required by the custodian and by the Government Records Office, and in this case, the court. The court said in this order dismissing the case, and I quote, "In carefully weighing the particularized interests of the parties," and the parties were Ms. Clausen and the Lieutenant Governor's office, the court also notes that the privacy interests of voters, especially those who have explicitly requested that their personally identifying information be kept private, outweigh the transparency-related interests of plaintiff petitioner. First, the court notes that Utah law contains transparency-related protections in the signature gathering process, such as the delegation of authority to county clerks who, as election officers working in Utah's 29 counties, validate all petition signatures submitted by signature gathering candidates. This pre-existing transparency measure within Utah cuts against petitioners' particularized argument. Second, the court recognizes and acknowledges the myriad concerns, including identity fraud related or otherwise, the myriad concerns for most voters related to the prospect of their signatures, in this case from election petitions they have signed, their signatures being disseminated by the custodian of records, in this case Lieutenant Governor, outside of government offices to third parties. Moreover, from the statutory protections for voters' personal information as codified in GRAMA, the court infers that the Utah legislature has already done the weighing of interests analysis of its own and determined that voters' privacy interests outweigh those individual interests, such as petitioners. So the court has already weighed this kind of conflict between what the petitioners are calling transparency and the statutory right of voters to keep their information private. And I think that concept is kind of what underlies all of these various GRAMA requests. But as to the two that we're here to consider today, we assert that the Lieutenant Governor's office did not violate the statute and that the office's response in these situations was reasonable and within her authority and is required by the statute. And so we ask that you deny these appeals.
And one point of clarification. So there are the two packets, one's an archive, one's at the Attorney General's office. Or does the office see the custodian of those records to be archives and then the other custodian to be?
No, I think, and correct me if I'm wrong, but I think once you're the custodian of the record, it stays within that agency or office. And the fact that they handed them over to archives, I don't think changes that. Maybe I'm wrong. And I do want to point out for the record, you say there's one packet at the AG's office and one packet at state records. Packet probably isn't the right term to use. There is a tranche of packets that each contain, any number of signatures. And one was looked at in the Auditor General's process. The others are those that were handed over to the Attorney General's office, where they are.
With the Attorney General's office, the custodian, or do you think the Lieutenant Governor would?
I don't think so. Technically, I mean, they are right now, they're the holder of those. And as long as they are, and I guess I didn't mention, but the one provision of grandma that the LG's office cited as a basis for denying providing those is this at 63G2305 sub 10. Protected records are or include 10 records created or maintained for civil, criminal, or administrative enforcement purposes or audit purposes, or for discipline, licensing, certification, or registration purposes. Release of the records reasonably could be expected to interfere with investigations undertaken for enforcement, discipline, licensing, certification, or registration purposes. And so those are the reasons that these suspect, I guess, packets, signature packets, were handed over to the AG's office as the law enforcement and investigative agency.
I don't know if you can answer this question, but are you aware, is this investigation still ongoing?
I think it is still ongoing, but I don't know what the estimated and as Ms. Clausen pointed out, they're within that group that the Attorney General's office holds. That is that group of signature packets. There were some that were from the Washington County context. There is some from Benson Angular. Probably shouldn't be saying names, but and then the other ones are the Spencer Cox campaign.
Do you anticipate, like, when the investigation is over, the Attorney General will return those records to the Lieutenant Governor's office?
I think that's the practice. Yes, I can't say for certain, but I think that's generally the practice, or they box them up and send them off and store them as, evidence files. I don't know what the retention schedule in that context is, but they'll either give them back to the original custodian or hold on to them as evidence for whatever the retention schedule is. So,
thank you. Mr. Clara, can you just clarify for me, was the avenue of a grandma request to the state auditor pursued to see if they had a list?
Yes.
They did not.
Yeah, they said that it was what the Lieutenant Governor had it.
And also, if you could respond to, there are voter records and voters who have filed to have their information protected. And it sounds like those would be amongst some of the records that you're looking for.
No, that's not an issue for us, for me today. I mean, I know what he said, but I'm not asking to view the private or withheld names at all on the list, on the packets.
All right, so thank you for answering these questions. We're going to give, again, 8 minutes for rebuttal and closing. Let's start with you, Mr. Clara.
Okay, so let me just, for context, one of we call them the unreviewed packets. And, you know, he said I did like 30 grammar requests over the last year. And one of those I asked for, you know, I said, give me the cover sheets then for these unreviewed packets. And this is what they look like. So when he clarified that it's not really a packet, we're talking about packets. So in this case, we're talking about 2 different batches of packets for clarity. So what they sent me, the lieutenant governors, and this is what the cover sheet looks like. And then I just added these pages because they have 5 pages to them. So this is what they would look like. And what the lieutenant governor's office sent me. So this would have all been solved for me is when I said, I know there's 592 unreviewed or spared signatures. So I'm trying to just confirm that with the public record. And so when they did send me those, and I get 15 of these, but it only adds up to 320 signatures. So we're missing almost half of the signatures, but they don't tell me we're withholding half of them, half of these representing half of the signatures. Under grammar, they should have told me they're withholding that number, and they didn't tell me why, the classification. And at this time, when I'm asking for this, let me go back into last year, in July, when the court case was going on with Lyman and Clausen, and they want to view all of the packets. Then I do a grammar request for the investigation into Governor Cox's signature list because I get told, I'm on social media talking about it. So some people contacted me from Vineyard, Utah and said, hey, we just got visited last week by an investigator from the Attorney General's office. She gave us a business card and here's a case number. So I do a grammar request for that. What I thought was going to happen is I was going to get a letter back from the Attorney General saying, in fact, it was Lonnie Pearson. I was hoping he was here today. He's the one, the records officer said, we don't have that record. And then when I tried to schedule it, and then on appeal, it gets turned down by Burton on appeal. And then when I tried to schedule it for what was the SRC, the executive secretary rejected it and said, we're not scheduling it for a hearing because you don't have any evidence that this investigation exists. And I protested on email and said, I have the business card. It was in my appeal. So anyways, Mike, I just bring that up to say, you know, he's bringing up the issue of what the court decided, but the court didn't have all the information. You had the Attorney General's office denying that an investigation existed. And then it's not till recently that now you have the Lieutenant Governor's office saying it does exist and they want to protect the records because of an investigation. So on that issue, that is the protected status, I'm sorry, of the record they're invoking. And I would ask you to reject that. I would ask you to reject me. I would ask you to reject that because the SRC before you has already established there is no investigation. I did not ask Lonnie Pearson to recuse himself because I wanted to be able to sit here and say, remember you said that there was no investigation. So don't let them now invoke that there is an investigation and protect the records. And so I thought that would be an easy thing, but he's not here. So it's something that you'll need to consider. And if there is an investigation, he has a burden of proof to demonstrate why releasing those records would interfere with the investigation. And I haven't heard any. He mentioned that and he's correct, we mentioned it too, before he did, Angulau is the subject of that investigation. And by the way, when here are files that I have on the records that I could get through the courts on the 5 people that were employees of Gather and Eat. And Angulau has, when his case comes up on the court docket, it's AG 24170. That's the investigation that the Attorney General's office said didn't exist. And so now I have his indictment. I know everything about, I know how many packets he did. I know how many of those belong to Cox. So when we talk about batches, and this is just a simulation, is he has 11, I think it's 11 packets that, 11 are called packets that belong to Governor Cox, that were turned in for Governor Cox. So that's that issue about the protection. So these are the two packets. They're claiming right now that this set is with the Attorney General. And so what I'm saying is the problem that we have here is that in terms of wanting to confirm public records and election records, that half of the governor's quote unquote spare signatures. In other words, when he represents to the court in July of last year that there were 600 unviewed signatures that still could be counted towards Cox, he lied to the court. That was a lie. And Cheney's name is on the motion. He's the one that did it, because the truth of it was only these 320 signatures were verified by the clerk. And he just told us that these Angulau ones were not verified by the clerk. Then you know who verified them? The Lieutenant Governor. That's the only other person that could verify them. So what we have here is the Lieutenant Governor verified signatures for their own campaign. And that's why they should be released, because we need to be able to see that and verify what these others are, because these guys lost a court case last year based on I believe that were false statements by the Attorney General and the Lieutenant Governor in that case. And this is one way to rectify it, is by releasing these records. And then I'll just close with this, that the list is going to be the signature packets, that if they didn't put them into the Vista system, which I would concede they did not, but I think they were doing that to hide what they were doing and to play a shell game with this. But through Grandma, we're able to find out exactly, like I just pointed out here, what happened is that only half of these were really spare signatures, and the other half, they were turned in way before the deadline. They should have put them in Vista. They didn't. They set them aside, and then they go back and reharvest them to say, oh, these were part of Cox's spare signatures, so they're not in Vista. That's illegal. That's wrong of them to do that. So like Phil Lyman said, a government entity may not use the physical form, electronic or otherwise, in which a record is stored to deny or unreasonably hinder the rights of a person to inspect and receive a copy of the record under this chapter. And that's Utah Code 63G-2-20112. So the fact that they did not put them in Vista, that's too bad. It's actually, it's on the packet. And I know that because I went and visited with Tina Cannon and her staff in February this year, and they're the ones that did the audit in September that deals with these. And they said that they checked them. They talked about a red pen and a green pen, and they checked them on the packet if the signature was valid or not. So that's the list. And then you have these that they're claiming are with the Attorney General because of a criminal case. That criminal case is done. Last month, that case was settled. So the investigation is clearly done. The court case is done. And so the records should be released.
Will you respond just real quickly? Was the offer to view them public or privately not sufficient?
Thank you. So what happened was, and they can correct me if I'm wrong, what I remember was they said, you can come in and view these. It's going to cost you $590 for us to redact everything. And no, on mine, I'm like, yeah, these are the spares. He said right now that it was all of them. If it was all of them, I misunderstood that. If it's all of them, I might go raise $590 to view all the packets. But my understanding was that the 590 was just to review the spare signature packets, these. And then I asked, how many am I going to view? Because I was thinking, if you're going to let me view all 592, and then they said, they're only going to let me view 492, because that's the number that the legislative auditor gave. And I said, well, I'm not paying that. And then that's when I reverted to, well, how much would you charge me for the cover sheets? And they said $40. So I paid $40 and got the cover sheets. So I'm glad you asked the question, because I would say a compromise I would accept if you were to rule this, then just give me the cover sheets for the remaining signatures. And I would feel that this appeal is satisfied. That I don't get the list, but at least give me the cover sheets like you did on half of them already.
Thank you. Mr. Cheney.
I can't really speak to this polluted theory about the investigations with the Attorney General's office, other than to say that I know that amongst the various packets that the Attorney General is holding, there could be more than one investigation. The investigation would go to anyone whose signature appeared to be forged. So there could be 200 investigations. Another misconception is that the auditor or the lieutenant governor verified any signatures. None of the signatures that we're talking about today, either the ones that the excess, what we're calling the excess packets that were looked at by the auditor and the auditor general, or the ones that were flagged and given to the Attorney General's office. None of them was verified through the VISTA standard election signature verification process. And none of them was counted or included in the final tally of these candidates' numbers and applied against the threshold. So again, that's the reason that we couldn't just come up with a list, because even though the auditors did their thing, they didn't verify them through VISTA. And so the arguments that they've made here stand. As to, well, I have to say, I've heard some serious allegations to me personally. And as a lawyer, as an agent of the courts, I've been called a liar, and I've been told that I made misrepresentations to the court. And I want for the record to say that that is absolutely false. And I think it's really not germane to what we're trying to do here anyway, but I do need to make that record. As to the one request about an ongoing investigation at the AG's office, and then getting later information that there was an investigation, as Mr. Colin Tanner pointed out, or was it Brody? One of these, Brody Bailey, who was at the time the chief administrative officer and records officer, stated in the denial of this appeal of, what is now 002, he said, at the time of your record request to the Attorney General's office, the packets had not been turned over for their review. The packets in question are now in their possession. And as to what another officer of the AG's office might have said at the time that they requested, that is, there is no investigation. I can't say whether, I wasn't there for that conversation, but my understanding is that, these things take time. And at the time that they may have asked, there was no investigation going on for the particular, the signatures that it was inquiring about. But again, that's not for this tribunal to wade through and figure out. Again, I want to come back to the Lieutenant Governor's statutory compliance and ask that these appeals be denied. Thank you.
Thank you. So I'm gonna need a few minutes to deliberate on this, at least take a short recess, 5-10 minutes. It's normal. It's like 5 minutes. What's normal?
As long as you need, we can do 5 minutes.
We brought a lunch, so take your time.
Maybe 5, maybe 10.
Take your time.
Even. There's a lot of people. Your shoes. I hear you weren't hired to get you. In a minute. Has to be out of the holiday and stuff.
Right, we're back on the record.
Technical
Station. Consider, they've made some very good arguments.
That sense.
Such good arguments that I really feel that this issue warrants more deliberation, a review of the code, just more interpretation. So for now, I'm going to take this matter under advisement and issue a written decision within 7 business days, at which time the parties will have 30 days to appeal to district court. That said, for the second appeal, I know it's going to have a lot of the same arguments, a lot of some evidence presentation. Is there anything different that you would like to add, or would you like to just submit on what you've already presented?
Yeah, on the second one, I would just withdraw my appeal and just, like you pointed out, the arguments are the same. So there's no need to go to the second appeal. I'll just withdraw it and wait for your decision on this one.
But do you have any issue with that?
No, I don't, other than to say, I think we addressed the issues for the separate appeals in our prior.
Yeah, I definitely feel like I'm back and forth on that. Okay, excellent. Well, then you will get my opinion in 7 days, written business days, and till then, we are adjourned. Thank you.